So I want to bring in now CNN's national security analyst Julia Kayyem, CNN legal analyst Michael Zeldin, who was Robert Mueller's special assistant at the Justice Department, and CNN legal analyst Laura Coates. Good evening. Thank you all for joining us. So, Laura, we have heard reporting that Trump's attorneys don't believe that Mueller has the right to subpoena. So if they fight this in court, how do you see this playing out?
Well, Trump's attorneys are wrong if they think that Mueller does not have the authority to issue a grand jury subpoena. Remember, there is also precedent for this. Ken Starr also issued a subpoena to then-President Bill Clinton. Now, he ended up withdrawing it once Bill Clinton decided to voluntarily agree to a videotaped testimony in front of a grand jury. But they're wrong to think that there is absolutely no precedent to say that the President of the United States could, in fact, be not above the law. In this case, you have the grand jury for the purpose of saying we would like to compel testimony in a criminal matter. We already know the Supreme Court has been very, very adamant, and lower courts now are starting to agree, in New York particularly, that the President of the United States is not only not above the law, but that they must comply with subpoenas to testify in civil cases at least. Now, a criminal bar is one in which we hold a great deal more water in, so it's a real fallacy to think that they could not compel this. But still, Don, there is still some reason for Mueller to try to get that voluntary or cooperation. And the reason for that is it will drag out the battle about whether the president can testify or whether he will then be compelled to do so. And it's the definition of a stall tactic that's being used by Trump's team to suggest that they could not have the power to do so.
Okay.
And that stall is a problem for an investigation.
Well, Julia, Jeffrey Toobin thinks that President Trump will ultimately take the fifth. I mean, what do you think about that?
I mean, I would advise him to if I were his lawyer, given how we know he responds to questions. And I think that, just picking up on what Michael said, I think that would be unfortunate. We tend to view the Mueller investigation as solely a criminal investigation, that this is going to happen in court. But actually, Mueller's mandate is different. It is to provide a report that sort of describes the contacts of the Russian influence through the Trump campaign in the 2016 election. The indictments that we're seeing, the plea arrangements that we're seeing, are in some ways incidental to the sort of national security review that Mueller's mandate is, which is, did a foreign power influence this, and so influence the election. So while Trump would be beneficial to that narrative, he is definitely not necessary at this stage. And I think the only reason that he would speak is if he could speak honestly about evidence that made him look or is innocent. And unless he can do that, he ought to take the fifth, or challenge this in court that he has to testify.
Well, if I can say, I disagree with the purpose on one point of that at least. And one is, first of all, when we're talking about the Fifth Amendment, remember that you can only plead the Fifth to questions that might incriminate you. You can't come in and have a blanket statement of, I'm pleading the Fifth to this whole experience. I don't feel like talking to you. And normally that you would have that be political suicide, but he has political cover now from having to say it's a witch hunt, and to say pleading the Fifth is him talking about a witch hunt, not about incrimination. But the bigger issue here is also that the President of the United States does need to testify, not just because it's incidental or because Mueller has meandered away from the directive, but because part of this deals with the president's state of mind. In that 49 list of questions/topics, it deals with the one thing the President of the United States can only answer, which is whether or not he intended to obstruct, what his mental state was when he answered questions to Lester Holt, what he knew about the Donald Trump Jr. Trump Tower meeting, what he wanted, why he wanted to fire Michael Flynn, what was the real reason for his animosity towards Jeff Sessions. All those things are not part of and outside of the scope of Mueller's investigation. They are poignant and they resonate with the actual terms of the mandate.
Okay. Right. And another key factor in all of this is the raid targeting Michael Cohen's office, his home, his hotel room. I mean, it left President Trump fuming and reportedly changed the president's view on whether he would sit for an interview with the special counsel. Right, Laura?
It did. I mean, that's the reports. He even says that Rod Rosenstein told him that he was not a target of that particular raid, that it was his correspondence or his privileged information with then Michael Cohen, if he really is his attorney and not a personal fixer, was not the target of this. But I actually suspect, Don, as many people do, that the reason the president does not want to sit in front of Mueller or his investigative team has very little to do with Michael Cohen and a lot more to do with his lawyer's advice and perhaps his own combination of common sense to say that it would be problematic if he were to meander or he were to answer in these open-ended questions that you and Julianne were talking about, because it gives him an opportunity to have softballs, get comfortable in the room, and then begin to weave tales and tell things that may be misstatements or misrecollections that could get him hurt in the end.
Yeah.
So I suspect he didn't want to do it for a variety of reasons. It's convenient that Michael Cohen, his raid, bolstered his reason not to want to do so.
All right. Thank you, everyone. I appreciate it.
All right.